It's 23 minutes past 10. You're very welcome back to the programme. Now, we're told that unmarried fathers legally powerless to stop their biological children leaving Ireland with their natural mother. To read more into this, we're joined on the line by Maria Connolly, a solicitor with interest in family law. Maria, good morning.
Good morning, Greg.
This is an area, and I think many, perhaps both mums and dads, would not be aware that unmarried fathers, I believe there may be a form that you can fill out to get certain rights, but have very little rights in certain cases, don't they?
That's correct. Well, they don't have the same automatic rights that married fathers have. On the birth of their child, they don't have any automatic rights to custody, guardianship and access, and have to take active steps to obtain those rights. Married fathers automatically gain those by virtue of the fact that they are married to the mother.
And is this just a gap in the law, effectively?
It is, yes. We are currently governed by the Guardianship of Infants Act 1964, and it simply has not been updated to move with society and changes. I suppose in 1964, fathers, there was a lot less unmarried fathers, if you like, in those days. And I suppose fathers were not as hands-on in the upbringing of their children as they are now. Even married fathers in those days didn't have this, have the same hands-on role as they do now. Fathers play a very important role in their children's lives.
Or perhaps women in the 40s and 50s didn't. It wasn't even considered perhaps that they'd have that freedom of movement.
Exactly. There's a lot more freedom of movement at the moment, and obviously with cheaper travel, etc., that has become more prevalent.
So, in a nutshell, if I were to have met someone 4 or 5 years ago, we had a child, lived together for 4 or 5 years, and they decided that they wanted to move abroad, and we were unmarried. As it stands now, I would have no power in stopping the child moving to another country.
Not unless you had been appointed a guardian either by the mother or by the court.
And how does one go about doing that?
Well, if it's on the consent of the mother, she can simply sign a statutory declaration confirming that she consents to your appointment as a guardian. That declaration simply rests with, it can either be done with or without a solicitor, but it's just a piece of paper. There is no central register, if you like, for registering the existence of that declaration. The other means of obtaining guardianship, and in my experience, the more common means of obtaining it would be through the courts. And again, it can be done on consent. The application is brought by the father, and if the mother consents, she can again sign a declaration which would be handed into court. If she does not consent, it would go to a hearing, and if the father is carrying out his parental responsibilities on a day-to-day basis, and it is in the best interest of the child, then the court will have no hesitation in awarding guardianship.
It's incredibly unequal, though.
It is. There's an inequality that exists there between unmarried fathers and married fathers, and indeed mothers and fathers, and unmarried fathers in general.
Your experience, do you think it's a conversation maybe couples avoid because, you want to feel that everything's rosy in the garden, and I suppose by doing this you are
you're rattling the cage.
Precisely, yeah.
Yes, you're upsetting the apple cart, and that is definitely something that I have experience of, and also in addition to that, unmarried fathers don't actually realise that this inequality exists, unfortunately, until a problem arises and it's upon them,
So if, just a scenario, it's an unpleasant one, but it's there nonetheless, if the mother were to pass away, an infant child, then who becomes responsible for that by law if the guardianship hasn't been officiated?
Well, depending on whether she had appointed a testamentary guardian.
Well, let's presume that hadn't happened.
Yes. Well, in that situation, the father would have to apply to the court for guardianship to be appointed.
So you could have a scenario whereby he could face off with the parents of the woman, as an example.
Exactly, yes.
So you would encourage anyone who's in this position to, what would your advice to them be?
Well, at the moment, my advice would be to, obviously speak to their partner if they're on amicable terms to see if they can get guardianship on consent. And if not, then they should make the application through the court, because the implications are quite serious for them if they don't. I mean, they just don't have the rights.
So could you have a situation whereby a man would be compelled by law to, say, pay maintenance for a child, but at the same time have no legal rights to the child as such?
Yes. Now, in fairness, if I have a client who has been served with a summons for a maintenance application, my first question is always, have you been appointed a guardian of this child, and are you playing an active role? Now, they may not want to play an active role in the day-to-day responsibilities and may not be involved with the mother or the child, and that is their own decision.
Yes, but I mean, is it not always best, though? Obviously, there are circumstances where it's not best. Is it not always best that a father and a mother are involved in a child's life?
Absolutely.
And people should be compelled to do that, not opt in and out.
Unfortunately, the court cannot force it upon a father if he doesn't want to be involved, but most of the time they do, and in my experience it's very rare that they don't. I think I've only encountered it once.
Do you find often that people come to you, they're in this scenario and the child in some way or other is being used as a lever or a bargaining chip?
Yes, unfortunately that's very prevalent in family law, and it's very difficult for the courts to deal with that, because obviously if a court order is made for access or any court order in family law is made to respect the child, and that's not being abided by one or other of the parties, the ultimate sanction in normal contempt of court situations is jail. But a judge is not mindful to do that in circumstances. It's not in the best interest of any child for either parent to be in jail, and it doesn't help the situation. So it's very difficult for them to deal with that situation. I have seen them trying to encourage either parent during the court proceedings, that it is in the best interest of the child that the father is involved, or indeed the mother is involved, etc. And they're very encouraging of that, but it is difficult for courts to deal with it.
And is there any, like, say, for instance, European law, what have you, say, for instance, a mother moved with a child to England and the father remains here? I mean, does he have any route through the courts on any level to try and get that decision reversed or affect change on it in any way whatsoever?
If he has guardianship rights, it is much easier, because we're a party to the Hague Convention, and most other countries are, especially in Europe. So if a mother moves without the consent of the father, it is abduction. And once we're part of the Hague Convention, there's procedures in place there for speedy recovery of the child back to this jurisdiction. Unfortunately, the lacuna exists where the father has not obtained guardianship rights. That is not considered abduction, because the father has no right to decide where the child resides in the first place.
And that applies in European law as well, really, is what I'm getting at. I mean, could you not try and address that at a higher court?
The European courts have they have looked at the situation here. It has been stated to them, and they haven't said that we're in contravention of any European law at the moment. The fact that an unmarried father has to apply for guardianship, because they can do that.
They have the choice, yeah.
Yes, that is sufficient for EU law. However, the Law Reform Commission here in 2010 did make recommendations that unmarried fathers would obtain guardianship upon the joint registration of the birth of the child. So in other words, they would now be expected to be on a birth certificate except in very limited circumstances, and upon being put on the birth certificate, they would obtain automatic guardianship rights. However, that has not been put in place as of yet. It's simply a recommendation.
So that if the father's name's on the child's birth certificate, that doesn't give any extra?
At the moment, no.
Okay. And can you opt out of guardianship out of interest? No. Not that anyone would want to. It seems probably just a curiosity. I mean,
I think that it would be more likely that in those circumstances, the mother would, if the father isn't playing an active role, she wouldn't want him to have a veto then on where she lives, and that would be unfair to her if he's not involved at all. And I think in those circumstances, she probably will. There will have to put a mechanism in place whereby she can apply to court to have him removed. But as I say, until they actually make it an automatic right, it hasn't occurred yet.
The last time we discussed this, I'm not sure it was myself and yourself, but it was 2 or 3 years ago, and there was talk of this being looked at. It obviously hasn't been at this point.
No.
But after I had the conversation and I was out and about and talking to people, they were, even those in this situation were completely unaware of that, be they male or female. So if that is the same now, what should people do, be the woman or the man, to address the situation?
Well, at the moment, all I can advise and all I can say to any clients coming into me is that they should take the necessary steps to obtain the guardianship rights. There's nothing else they can do at the moment. And whether it be with the consent of the mother or not, they should take those steps until they actually update the legislation and change the law. That's all they can do at the moment. But the problem is there is a lack of awareness out there, and I have discovered that. That's basically why I'm speaking to you this morning. And
just one other scenario: if the father does manage to acquire these rights, but they split up, and either partner gets another partner, if that makes any sense. I mean, how many guardians can a child officially have? Maybe the mum would want if she thought the father wasn't living up to scratch, maybe she'd want her new partner as the official guardian. I mean, does that come up?
No, it doesn't. I mean, if the natural father is involved and is a guardian, the courts would not to appoint somebody else.
Caller asks again, if the father's name is not on the birth cert, can he apply for guardianship?
Absolutely, yes.
And how would that be proven? The mother would declare it?
Well, unless if she's going to contest it, then they would have to...
No, but I mean,
if she's going to contest his paternity, there would have to be a test carried out to prove it.
So is there a different way? In other words, if you have to prove that it's the paternal guardian, if you know what I mean, the father?
Yes, you would. If there was any doubt, the courts would probably request it to be proven.
Okay. Right, okay, that's most of the comments here are just opinions on that as such rather than sort of seeking clarification, Maria. So we appreciate you coming on. Thank you very much.
Thank you, Greg.